Hey guys, and welcome to today's video. We've got something pretty special lined up, as every now and then the universe decides to give us a perfect storm of courtroom chaos. Today, all the planets have aligned to bring us a rare specimen, a full-blown Karen who also happens to be a sovereign citizen. And just to make things even more entertaining, she has chosen the absolute worst moment to fire her attorney and represent herself. During a probation violation hearing, yes, you heard that right. She's walking into one of the most serious stages of her case without a lawyer, armed only with misplaced confidence, questionable logic, and whatever legal knowledge she managed to gather from internet forums and self-help videos. Probation violations are already uphill battles, even with competent representation. Doing it solo while trying to argue fringe legal theories is like trying to climb that hill while dragging a refrigerator, so buckle up. Because this situation is about to turn into a masterclass in how to make your own life significantly harder with a single decision. Let's dive in and watch this courtroom journey unfold, one avoidable mistake at a time.
Clark, 22 CR 216, Mr. Fosgrave.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Got this myself should honestly be engraved on a warning sign, because those are the famous last words of every person who vastly overestimates their own abilities. And in today's case, our Karen has decided to embody that phrase perfectly. She marched into court with the confidence of someone who thinks common sense is optional, fired the attorney who had already negotiated a solid deal on her behalf, tossed all that work out the window, and chose to represent herself in a probation violation hearing, one of the worst possible moments to try to go solo. This isn't a traffic ticket, and it's definitely not the time to experiment with do-it-yourself courtroom tactics. A probation violation hearing can determine whether you walk out the door or get taken straight into custody. And she's treating it like it's a customer service dispute. Her lawyer had spent time building a pathway that could have minimized the damage, maybe even kept her out of further trouble. And she threw that away with the kind of impulsive confidence usually reserved for people who think they can fix electrical wiring with a butter knife. So now, here she stands, proudly walking into a legal minefield with no map, no shield, and no understanding of how dangerous it actually is. But don't worry, there's one thing we can count on. It's that she's about to turn a difficult situation into a full-blown disaster. And we get to watch the entire thing unfold in real time.
Okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them. But you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
I have to admit, I admire her confidence even if it's built on absolutely nothing and is almost guaranteed to get her rested before this hearing is over. Honestly, that might be why it's so entertaining. There's something oddly fascinating about watching someone strut into a legal situation with the confidence of a seasoned attorney, while armed with the knowledge base of someone who skimmed a blog post about knowing your rights. But confidence won't save her now, because the prosecution is about to bring out the one witness they need to dismantle her entire self-made disaster, her probation officer. And if there's one person who knows every slip-up, every missed requirement, and every poor decision she's made since being placed on probation, it's that officer. This isn't someone she can talk over, out-argue, or intimidate with buzzwords she found online. This witness has the receipts, the reports, and the records everything necessary to turn her self-representation into a textbook example of why lawyers exist. So buckle up, because the moment the probation officer steps forward, we're about to watch her "I've got this" attitude collide with reality at full speed.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
What is wrong with you people? Honestly, it's the biggest problem with sovereign citizens is that the so-called gurus they follow only ever teach them the first step, how to fire their attorney. That's it. That's the entire curriculum. They hype them up with buzzwords, half-understood legal jargon, and fantasy interpretations of the Constitution, all leading to that grand moment when the defendant dramatically dismisses their lawyer in court like it's some kind of victory. But once that moment is over, reality hits them like a freight train. Because after the attorney walks out of the courtroom, the gurus conveniently disappear. Suddenly, the sovereign citizen realizes that building an actual defense requires more than YouTube videos and pseudo-legal catchphrases. There's a reason successful sovereign citizen defense isn't a real thing, needs uncharted territory. Not because it's groundbreaking, but because it simply doesn't exist. No one has ever charted that map because every person who tries ends up lost, confused, and sinking fast. And that brings us to today's crash test dummy. The moment she became responsible for her own defense, she didn't just make mistakes, she buried herself. She's navigating a complex legal process with the equivalent of a treasure map drawn in crayon. Every argument she makes is another swing of the hammer on her own case. And every attempt to stand on her rights just pushes her further off the cliff she built for herself. It's painful, predictable, and yet undeniably fascinating to watch. So let's continue and see how much more damage she manages to inflict before this hearing is over.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clerk, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing.
This should be good. Up to this point, her entire legal strategy has consisted of doing absolutely nothing that resembles an actual defense. She hasn't challenged a single piece of evidence the state presented, hasn't introduced anything on her own behalf, and hasn't even attempted to create reasonable doubt. It's like she wandered into court thinking she could win by simply existing in the same room as the judge. So, now we've arrived at the closing argument. Her last chance to show us whether there's any method behind this chaos, or if she's just been freestyling her way through a legal proceeding. She clearly doesn't understand. And honestly, this might be the best part, because the closing argument is where she gets to reveal the full depth of her reasoning skills, or lack thereof. This is the moment where we all get to find out just how far her confidence can stretch without any substance holding it up. Based on her performance so far, I'm fully expecting a speech that sounds less like a legal argument and more like someone trying to solve a puzzle they didn't know was upside down. If nothing else, it will give us a very clear measurement of the intellectual tools she brought with her. So, while it seemed to consist entirely of stubbornness, misplaced certainty, and whatever she managed to piece together from fringe internet advice. So let's dive in. Because if her closing argument matches the rest of her strategy, we're in for an unforgettable display of self-sabotage.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
This should be good, especially since her legal game plan so far has consisted of sitting there like she's watching a commercial break, no objections, no challenges, no counter-arguments, nothing. The state could have wheeled in a chalkboard with stick figure drawings labeled "Karen did it," and she still wouldn't have said a word. At this point, the prosecution isn't even winning. She's just letting them score on an empty net, and then she hits us with this gem about the IRS, as if she's uncovered some grand conspiracy that the courts somehow missed. You know, there's a little saying where I come from. You're worried about the wrong thing, Karen. Because the IRS isn't the one dragging you back into court. The IRS isn't the one testifying against you. And the IRS definitely isn't the one asking for your probation to be revoked. It's the state of Kansas' actual opponent. The one you haven't bothered to prepare for because your entire defense strategy seems to be fueled by Google searches and blind optimism. So she's played her stupid game, fired her lawyer, ignored the evidence, lectured the judge, and mixed up the agencies involved in her own case. Now it's time for the moment we've all been waiting for, finding out what stupid prize she managed to win. And given everything we've seen so far, I'm guessing it's not going to be a ribbon or a coupon book. No, she's about to collect the deluxe, all-inclusive consequences. Package that comes standard with representing yourself while having no idea what you're doing. Grab some popcorn, because this is the part where reality finally catches up to her confidence.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Whoa. $1,200 a minute for every minute you're in jail. Hold on, Karen. Let me grab a calculator because apparently we're doing fantasy economics today. Let's break this down like she's pitching a business plan on a reality show. 60 minutes in an hour, 24 hours in a day. Carry the one. Round up for delusion. And wow. According to her math, she'd be racking up enough imaginary money per day to buy a small restaurant, a handful of used cars, and a lifetime supply of cheeseburgers. Seriously? That's a lot of cheeseburgers, Karen. At that rate? The debt she thinks the government owes her would rival the national budget of a small country. You'd think with numbers like that, she'd be walking into court with a golden briefcase and a calculator made of diamonds. Instead, she's standing there arguing with the judge while confidently presenting math. That wouldn't pass a fourth-grade word problem. But that's the magic of sovereign citizen logic. They can turn jail time into profit margins, court orders into imaginary contracts, and simple probation violations into conspiracy theories. Meanwhile, the rest of us are just sitting here watching her add zeros to the air, wondering how someone can multiply their confidence while dividing their common sense at this point. If Karen truly believes she's earning $1,200 a minute.
Alright guys, that's the end of the video. As it turns out, having a public defender is way more effective at ensuring your freedom than representing yourself and doing nothing at all. So if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.